Welcome to the final panel of the session. My name is Burt Newborn, and I'll moderate the panel. I learned one thing, I learned a lot of things in the last 2 days, but I learned one very important thing, and that's the only way you can be heard in this room is to speak from the podium. And so my suggestion is that if it's not inconvenient for the panelists, that you deliver your remarks from the podium, and I'll do the introduction from the podium as well. I want to join the chorus in thanking Mike McConnell and Nate Chapman for setting up the conference, which has just been delightful. I have a special bit of gratitude in thanking Michael and Stanford for inviting me out to teach here for these 5 months, and it's been quite extraordinary. I didn't think that Woody Allen could be happy in paradise, but it's true. You can be happy in paradise, and so I'm having a terrific time, and I thank you for it. I'm going to say also that I found that the panels, beginning with Judge Randolph's description of Henry Friendly's opinion, all the way through the panels have been extraordinary, and I think we owe a great debt to the panelists and to the organizers. And the metaphor that I take away from the 2 days is the metaphor of hammers and scalpels. The philosophy and ethics that we heard this morning, and that we heard little bits of in virtually every panel, convinces me that philosophers do work with scalpels, and that the moral issues raised by the termination of whatever you want to call it, an incipient life, a fertilized egg, a fetus, a life worthy of human dignity, whatever semantic label we pin on it, the termination of that raises extraordinarily difficult moral issues that we've heard debated by the philosophers and ethicists in an extraordinarily careful way. And they do use scalpels. And the scalpels persuade me that speaking individually, individuals, this is an unbridgeable moral gap. That the decision of when the life begins, what a life is, and what can be balanced against a life is of such difficulty and of such moral ambiguity, as we've mentioned over and over again in the 2 days. There isn't any way that you can expect a society to come to a consensus on that issue. In fact, any healthy society is going to have very, very vigorous disagreements about how that issue comes out. And so it shouldn't surprise us that no matter what we do, operating with scalpels, we are never going to be able to get a single answer and a consensus answer to the problems raised by Roe at 40. On the other hand, lawyers operate with blunt instruments. We operate not with scalpels, we operate with hammers, because lawyers deal in force. Lawyers market to the society coercive measures. Unlike philosophers who speak in the language of ought, we speak in the language of must. And under those circumstances, the blunt instruments that we're trying to use to forge some form of stable political approach to the moral issues raised by Roe 40 years after the decision, it's no coincidence that that is extraordinarily hard to do. And at the risk of oversimplification and introducing this extraordinary panel, let me suggest that what got distilled to me through the 2 days of discussion was the fact that we have abortion inevitably raises the clash of values of constitutional magnitude. On the one side, respect for life, which must be a value of constitutional magnitude and must be something we dedicate ourselves to. And that if that's all we had, if the only thing on the scale was respect for life, then the issues would not be particularly difficult. Then you would get the kinds of statutes that recognize the legal personality of a fetus in the context of where somebody tries to murder the fetus, because there's no countervailing values on the other side. What makes the abortion debate so difficult is the existence of at least 3 major countervailing values on the other side: the autonomy of the woman, the associational privacy of the family and the act of having a family, and the gender equity issues that are latent in whether a woman can control her reproductive life. Now, speaking for myself, if I were convinced that a life were at stake, a genuine life to which I was obliged to ascribe full dignity, that balance still goes for the life. And I understand that that's how many people view it, and I respect those views. If you honestly believe that it's a life, the countervailing values are simply not enough. On the other hand, if you're not sure, if there's uncertainty, then the existence of the countervailing values make this an excruciatingly difficult problem. And an excruciatingly difficult problem, essentially in error deflection. Because what we're doing is deflecting error on whether we're sure it's a life or we're not sure it's a life. And deflecting and the existence of the countervailing values seems to me tells us something about how you structure that problem. And the issues that have gone back and forth is, when we're not sure, do we let the majority decide it? That's the argument that says, leave it up to the legislatures. If we're not sure, do we let the judiciary decide it? Do they have the capacity to make that institutional decision? Or if we're not sure, do we ultimately leave it to the conscience of the affected woman working in connection with her doctor? The debates that have swirled around Roe have tended to swirl around those issues. Exactly what the balance should be, exactly what the institutional makeup of the components for reaching it. Now, this panel is particularly interesting because this panel at Roe at 40 asks, what's Roe going to be like Roe at 80? What's going to happen in the next years when we have the kind of technological and scientific changes that could alter the way we think about the balance? And so the question is will there be likely to be those kinds of technological changes that alter the balance? And the organizers of the conference have put together a superb panel to do it. In the order in which they're going to speak, there's Professor Radhika Rao at Cal Hastings, who, in some sense, comes directly to us from the source. She clerked for Harry Blackmun, and she clerked for Thurgood Marshall. And she's written widely on the intersection of constitutional law, science, and public policy. And secondly, Hadley Arkes, who's the Ney Professor of American Institutions at Amherst. Now, Hadley is the leading natural law theoretician in American constitutional law. Deep down, I believe we're all natural lawyers. When we pretend we're not when we're constitutional lawyers. We always pretend there's text. But I believe we're all natural lawyers. Hadley's the only one who admits it. So that he is the leading natural lawyer of his era. Then there's Dr. Monique Chireau, who is a professor of obstetrics and gynecology at Duke Medical School, and who has worked extensively at the frontiers of the science of the development of the fetus and pregnancy itself. And finally, there's Hank Greely here at Stanford Law School, who's the director of the biomedical ethics program here and who is one of the nation's leading authority on the intersection of science, biomedical ethics, and law. And so my hope is that this panel is going to tell us what the world is going to look like in the next 40 years so we can start thinking ahead to Roe at 80. Professor Rao, do you want to start? And I hope that we can speak from the podium.
Okay, so many thanks again to Michael McConnell and to Nathan Chapman and to all of you for inviting me here to this fantastic conference. The topic for this panel is what novel reproductive rights issues will the court face in the coming years and how should it address them? Well, I have lots of questions that I want to pose first, but then I'm only going to turn to one to answer. Does Roe protect only the woman's right to remove the fetus from her body, or does it also include a broader right not to procreate, a right not to have a genetic child? Does the abortion right even apply to situations when a parent wishes to destroy an embryo that is located outside of a woman's body? And could a state prohibit the destruction or discard of IVF, in vitro fertilization embryos, or require that spare embryos be made available for adoptive implantation? Does the right to abortion encompass the right to terminate a pregnancy for any reason? Or is it constitutional for the government to prohibit abortions for the wrong reasons, such as sex or even race-selective abortions, as several states are currently trying to do? As non-invasive prenatal testing technology becomes widely available, enabling prospective parents to cheaply, safely, and effectively test for a number of genetic traits very early in the pregnancy, may the government respond by enacting reasons-based abortion prohibitions that would permit a woman to abort a fetus that is at risk of a serious genetic disease, say, but not for obesity, homosexuality, or skin, hair, or eye color? Or could the government instead limit access to such sensitive information as India currently does with respect to sex? And finally, does the right not to procreate, established in the contraception and abortion cases, entail a concomitant right to procreate, to have a biological child? Does it include the right to procreate with the assistance of technologies such as in vitro fertilization, intracytoplasmic sperm injection, or even somatic cell nuclear transfer, otherwise known as cloning? Does it extend to procreation with the assistance of reproductive collaborators, such as sperm and egg donors and surrogate gestators? These are all interesting and important questions, but I don't have time to provide answers, except to say that many of the new technological developments pressure the right to abortion by carving out political fault lines that pit those who favor protection of an individual woman's liberty and privacy against those who are more concerned about equality for women, the disabled, and other groups who lack political power. The answers to these questions will depend upon the contours of the constitutional right to privacy established in Roe, and whether it turns out to be grounded in liberty, or in bodily autonomy, or in sex and gender equality. And I would suggest that the Supreme Court is unlikely to take on these issues because they involve a clash of competing constitutional rights to liberty and equality in an area where technology is changing rapidly and social norms are still evolving, as in Washington against Glucksberg, where the court warned of the dangers that unrestricted individual liberty might pose to equality and advised caution in the face of rapidly changing technology and evolving social norms. Moreover, any cases that the court does decide are likely to result in indeterminate and unsatisfactory answers because they require the resolution of complex problems presenting multiple parties with conflicting rights, as in Troxel against Granville, which pitted the biological mother's right to rear her children against the conflicting rights of the grandparents. So those are the questions that I'm not really going to address. Instead, Instead, I want to turn to the issue at the heart of the abortion controversy, the moral and legal status of the embryo. But what I'm going to say is incredibly controversial, even radical, and it was probably going to please nobody. What exactly is an embryo? Is it a person, a type of property, or part of a woman's body subsumed within her right to privacy? Must we decide upon a uniform answer to this question? Whether women have a constitutional right to terminate their pregnancies would seem to turn upon the legal status of the entity whose life is being terminated. But I propose that it's the other way around. The legal status of the embryo or fetus rests upon the rights of others. I believe that the question of legal status is not intrinsic, but instrumental. Thus, the very same entity may be deemed the subject of a woman's constitutional privacy rights, the object of property law, or even a full-fledged person with rights of its own under the rubric of tort or criminal law. The choice between these different frameworks all depends upon the context in which the question is posed and the consequences of the embryo's status for the rights of others. 40 years after Roe, the status of the human embryo is still hotly contested. In Roe, the court held that the fetus is not a person, but in recent years, a number of states have sought to enact laws that would effectively personify the embryo and fetus. Some states, for example, compel women to view an ultrasound image of the fetus before having an abortion, while others require physicians to inform their patients that abortions terminate the life of a whole, separate, unique, living human being with constitutional rights that begin at conception. Personhood initiatives and laws limiting abortion on grounds of fetal pain or even the presence of a fetal heartbeat also attempt to endow the embryo with the attributes of a person. Along the same lines, the criminal laws that Clark mentioned at both the federal and state level often address the killing of a fetus, and in some cases even an embryo, as a form of murder. At the same time, widespread use of assisted reproductive technologies that involve the creation and manipulation of in vitro embryos, as well as the production and use of human embryos for the purpose of research and therapy, create additional sites of controversy. Advances in induced pluripotent stem cell research mean that sperm, eggs, and even embryos could be created someday from any cell of the body, suggesting that every cell could someday be seen as a potential person, and the destruction of any cell deemed a kind of murder. On the other hand, embryos may also be used to produce stem cells, which may result in new medical therapies, driving some to conceptualize the embryo as a valuable resource, a kind of property. In these different contexts, sometimes the embryo is treated as a part of the woman's body that is shielded by her privacy, while at other times the embryo is classified as an object of property, the subject of conflicting rights, or even a full-fledged person with rights and interests of its own. In this talk, I'm going to explore these constructions of the embryo and examine the factors that shape its legal status, including the location of the embryo, its stage of development, the purpose for which it was created, and the mode of its creation. Robert George suggests that there is no real controversy that an embryo is a human being in a biological sense. But I think there's a great deal of controversy as to what even qualifies as a human embryo. Does an embryo require the joinder of a sperm and an egg? Or does the concept also extend to a parthenote, an unfertilized, a truly unfertilized egg that has been tricked into dividing? Or does it encompass a clone, an egg that has had its nucleus removed and replaced by a somatic cell? Does it encompass even a human-animal hybrid? For example, an animal egg that has had its nucleus removed and replaced by a human somatic cell. An embryo's legal position may also depend upon the motives underlying its creation. Was it created with reproductive intent or for the express purpose of conducting research? Beyond the method and purpose of creation, the developmental stage of the embryo often defines its standing. The law may accord different treatment to an embryo at fertilization, upon implantation in a womb, after formation of the primitive streak, which occurs around 14 days after fertilization, or at the point of viability, which occurs between 20 and 24 weeks of pregnancy, when the fetus gains the capacity for survival outside the woman's womb. Finally, legal status often turns upon the location of the embryo, whether it is situated inside or outside a woman's body. I contend that the legal status of the embryo rests not only upon these important criteria, the where, the when, the why, and the how of the embryo, but also upon the context in which the question is posed and the consequences of the status for the rights of others. So in the US, women have a fundamental constitutional right to terminate their pregnancies under Roe and Casey, but close reading of these cases reveals that they guarantee only a woman's right to free her body from the burdens of pregnancy, not the additional right to take the life of the fetus. That is why Roe drew a sharp temporal line at viability, the earliest point at which the fetus is capable of survival outside the womb. Roe's viability line is confusing because it lapses, or it contains multiple meanings. Some scholars suggest that viability matters because it marks a stage of fetal development that corresponds roughly with brain birth, the point at which the fetus develops the structures that might ultimately lead to cognitive capacity and perhaps consciousness, which we might think to be critical to the moral status of a person. But I believe that viability is important because it marks the moment of independence. At viability, the fetus can be reasonably regarded as a separate entity rather than an appendage that is part of the woman's body, because it no longer needs her to survive. At this point, it may be treated as autonomous, a distinct being with interests in its own right. Thus, viability connects the legal status of the embryo with its dependence upon the woman's body, the fetus, I should say, confirming the importance of bodily integrity and sex equality to the abortion right. Professor Lawrence Tribe makes a similar argument, saying once the fetus can be severed from the woman by a process which enables it to survive, leaving the abortion decision to private choice would confer not only a right to remove an unwanted fetus from one's body, but also an entirely separate right to ensure its death. Recognition and enforcement of the latter right would be indistinguishable from recognizing and enforcing a right to commit infanticide. Viability, he says, thus marks a point after which a secular state could properly conclude that permitting abortion would be tantamount to permitting murder. Tribe's hypothetical, and I may be criticized for bringing in this hypothetical, arguably came to life with the practice of, quote, partial birth abortion, which involves not just the right to remove an unwanted fetus, but also the right to ensure its death outside the woman's body. Congress enacted a law that prohibits this method of abortion, which physicians call DNX, dilation and extraction, because the fetus is wholly or partly withdrawn from the uterus before it is killed, and the court upheld the law in a case called Gonzalez v. Carhart. Whereas Roe drew a temporal line at viability, I would suggest that Gonzalez v. Carhart drew a spatial line between the destruction of a fetus inside and outside the woman's womb. As Justice Ginsburg said in her dissent in Carhart, instead of drawing the line at viability, the court refers to Congress's purpose to differentiate abortion and infanticide based not on whether a fetus can survive outside the womb, but on where a fetus is anatomically located when a particular medical procedure is performed. And Carhart suggests that it is this spatial line that separates the constitutionally protected right to abortion from the criminal act of infanticide. This position was articulated most forcefully by Solicitor General Paul Clement at oral argument when he observed that the basic point of the law is to draw a bright line between a procedure that induces fetal demise in utero and one where the lethal act occurs when the fetus or the child, whatever you want to call it, is more than halfway outside the womb. Carhart may simply be unprincipled in its departure from the Supreme Court's own precedent in Stenberg v. Carhart, or its sole justification may be Dr. Leon Cass's repugnance principle, a yuck test essentially, that it is permissible to outlaw practices at which we recoil, which I believe isn't really much of a principle at all. But if there is a principled principle underlying Gonzalez v. Carhart that connects it with the rest of the abortion cases, I think it must be this idea that the constitutional right to privacy ends at the outer limits of the woman's body. And when the fetus is partly or mostly outside the woman's body, her bodily autonomy and equality are no longer uniquely at stake. At this point, she may forfeit her privacy right, and the government may dictate the method by which the fetus would die, even if the choice poses some risk to her health. If legal status were intrinsic, resting only upon the innate character of the embryo or fetus, then location would be irrelevant. But I think that the legal status of the embryo or fetus is not intrinsic but instrumental, so it varies in different contexts because it depends upon the consequences for others. And under my theory, location is critical because laws that regulate embryos and fetuses within the womb obviously have an immediate impact upon women's bodies and their status in society. But to the extent that government, this theory would give government great latitude to enact laws that regulate extracorporeal embryos that are outside a woman's body. so long as it does so in an even-handed fashion. So laws such as Germany's Embryo Protection Act and Italy's Law 40, both of which limit the number of embryos that can be created through IVF and prohibit the discard or destruction of IVF embryos, would be constitutional under my theory if they were enacted by the United States or a state government, even if they require women to undergo additional cycles of fertility treatments. Oh dear. Okay, so I have only a few minutes. So let me then talk about, I don't have time to talk about the embryo as a person. Clark talks about the criminal laws that treat embryos as persons. And the frozen embryo disputes treat the embryo as a form of property. But let me at least conclude with the idea of what an embryo is. So what qualifies as a human embryo? Some scholars say that the use of different scientific definitions would resolve this issue. Dr. Ann Kiesling says that an egg activated without sperm, a parthenote, should be called a parthenote rather than an embryo, and the product of nuclear transplantation, a clone, should be termed an ovosome. She suggests that we should avoid calling an egg fertilized by sperm an embryo prior to implantation in the uterus. I suggest that this kind of a move attempts to evade the substantive issues through definitions, and that we can't really do this. All of these tactics attempt to achieve substantive objectives through the manipulation of language. Congress has defined embryo expansively to encompass all these different entities for the purpose of funding in a bill that prohibits federal funding of embryo research. And the real question is whether we should bemoan this inconsistent state of affairs as unproductively chaotic or applaud it as reflecting a healthy pluralism. So I'm going to say that I think these questions cannot be resolved by resort to scientific truths, nor can they be evaded by the creation of new scientific terminology. Science holds no sway over the subject. Scientists shouldn't dictate the meaning of the word embryo because it is not a purely scientific question, but also a moral, philosophical, political, and ultimately a legal question. Let me end with something that Burt Newborn said in the Q&A. He said that the underlying moral ambivalence about Roe is not going to go away. And I believe that the underlying moral ambivalence at the heart of Roe rests upon this contested question of the moral and legal status of the embryo. I think this ambivalence should not go away. We should not seek to make it go away by providing a single answer to the question, what is an embryo? Instead, we can and should treat the embryo differently, depending upon where it is, when it is, and perhaps even why it was created and how. Of course, this answer is going to upset everybody. Pro-lifers who oppose abortion want to declare the fetus a person in every context, and those who support abortion fear that treating the fetus as a person in some situations might ultimately lead to a broader recognition of fetal rights and undermine a woman's right to abortion. But perhaps my rejection of the binary nature of this debate, sort of like Eastern philosophy, might ultimately lead us to a deeper understanding and embrace of multiple, plural visions of the embryo. Thanks.
Can you hear me? Yeah. Burt and I are comparing Woody Allen's stories, and at this hour, the apt one is, this is a watch that my father, on his deathbed, sold me. I came in to read the meter, and somebody asked me to stop and say a few words about the 21st century and reproductive rights. I think we have here a version of what we call at Amherst we've invited the wrong Reverend Jackson problem. Everyone is thanking Michael McConnell. I say it's his fault that I've been put on this panel because my own sense of things is that nothing in the new technology, no abortifacients delivered by iPads, nothing in the arsenal of Apple combined with Intel will alter the serious moral questions that will ever stand at the core of this matter now. Professor Rao confirms my point. If a human being and the embryo as an innocent being, if it does claim the protections of the law as an innocent being, that protection is utterly indifferent to its location and where it's receiving its nutrition, whether it's in the womb or in a petri dish. And if it's a matter of living, then if nothing is living and growing, then an abortion is no more indicated than a tonsillectomy. But if it is living and growing, we know that it's not changing its species in the course of its growth, and it's nothing less than a human entity from its first moments. Years ago, I offered this vision of a dramatic advance in technology, an electronic device with laser voodoo. A device no larger than a radio or a laptop can do the work that formerly required a whole room full of witches in Haiti, dispatching victims and leaving no marks. Now, with homicide rendered so much easier and perhaps undetectable, would anyone suggest that the laws on homicide had been rendered irrelevant? But similarly, the fact that we may have pills that can carry out abortions with diminished collateral risks as we go along, nothing in the advent of that technique can remove the question of whether we are destroying a human life, with what grounds of justification for destroying that life, and whether a pill of that kind could possibly be sold as an over-the-counter pill with no need for special permissions and no need to supply a justification for its use. And on the other side of this matter, we had the notable breakthrough in 2007 on the induced pluripotent stem cells, cells that were, as they say, patient-specific. It would not be rejected by the patient from whom they were derived. And all of this, along with the advances in the use of adult stem cells, have made it less necessary to engage in that research that involves the destruction of embryos. Yet none of this seems to have diminished the zeal to promote with a certain passion that research that is destructive of embryos, for that work seems to be driven by a rather distinct passion to affirm that the human embryo, that human life in its first moments, is not really a life that claims our respect. Now, as Harry Truman said, the only thing new may be the history we haven't read yet. Recall that 62% of the public in surveys indicates that they would reject abortion or prepare to ban abortion at the onset of a beating heart. But people don't seem to understand is how early we can get the measure of a beating heart. With a stethoscope, 18 to 20 weeks, with a Doppler device, 9.5 to 10.5 weeks, with vaginal ultrasound, 5.5 to 6.5 weeks. But all of that simply suggests that the definition of a human life would be made to depend on the current state of amplifier science at any point. What may be coming into play here is that old essay of Winston Churchill's on 50 years hence, imagining interplanetary travel, and what's the most interesting thing that could arise from interplanetary travel? We discover other creatures like ourselves, who will be affected by the very same questions. What is the purpose of it all? Whither are we tending? The questions, as he said, that emanate from those ancient cities of Athens and Jerusalem. And my point, I wonder here, is whether anything coming in the breakthroughs of the 21st century will be any more surprising than the science that we don't, or you already don't seem to know about, and which comes as a striking surprise to so many people when it's finally delivered. During the litigation in New York over the federal bill on partial birth abortion, Judge Richard Conway Casey turned to Dr. Kanwalit Anand, a professor of pediatrics and anesthesiology, testifying for the side resisting the law. And he asked Dr. Anand whether he thought of administering an anesthetic to that child, with 70% of the child dangling from the birth canal, legs wiggling. And Dr. Anand said, well, no, why would I do that? Was this a medical judgment? That the doctor couldn't possibly be any doubt that the child at that point could experience the most excruciating pain. The question didn't occur because Dr. Anand had evidently simply screened out the baby as an entity or person or even an animal whose pain somehow counted. But what he revealed there was nothing much different from what Bill Clinton revealed when he vetoed the bill on partial birth abortion and expressed concern for the woman whose health could be impaired by the denial of the surgery, of that other being in the picture, whose skull was being crushed and brain sucked out, he had nothing to say. That being just didn't register as a being whose presence or hurts counted. It's simply a version of that old scene in Huck Finn when Huck was trying to explain to Aunt Sally that we were late because the steamboat blew a cylinder. Oh my gosh, he says, was somebody hurt? No, I'm just a nigger killed. And she said, oh boy, it's a good thing. Sometimes real people get hurt in these kinds of things. If we were dealing with people whose education somehow encompassed a serious reflection of how you deliberate about this, and what is the ground on which you've eliminated that being as a presence, as a thing whose presence, whose hurts count. What's the principled ground? If we're doing that, the clearest model for us has ever been that marvelous fragment that Lincoln wrote for himself when he was imagining himself engaged in a debate or a conversation with an owner of black slaves saying, why do you think justified in making a slave of the black man? Is it because he's less intelligent than you? Beware, the next white man coming along, more intelligent than you, may rightly enslave you. Is it because he's darker? Beware again, the next white man who comes along with a complexion even lighter than yours may enslave you. It's simply a model of principled reasoning. There's at no point in the chain of reasoning is there an appeal to revelation or faith. Some of us have simply used precisely the same mode of argument over abortion. Why is that? That offspring in the womb, anything less than human, doesn't speak yet, neither do deaf mutes, doesn't have arms or legs. Other people lose arms or legs in the course of their lives without losing anything necessary to their standing to receive the protections of the law. Again, there's no appeal to revelation. Aquinas said that the divine law we know through revelation, but the natural law we know through that reasoning that is accessible to human beings as human beings. And it's curious here that the church's position has always been a mix of embryology and moral reasoning, not an appeal to faith. So it's rather curious to see how many people with pricey educations these days simply identify a moral argument with a religious argument and assume a religious argument is simply lacking in any cognitive content. The Supreme Court affected to be puzzled by the question of when human life began, but the Senate Committee on the Judiciary in the mid-'80s picked up the question and took a survey of all the leading textbooks on embryology and obstetric gynecology, and it turned out that there wasn't the slightest disagreement in the text on when human life began. It began with the merging of male and female gamete to form a zygote with a genetic definition distinct from that of either parent. 30 years later, the people at the Witherspoon Institute surveyed the same textbooks to find that nothing had altered. Mr. Obama was asked during the campaign of 2008 when he thought human life began, and he responded that that was a question beyond his pay grade, but which we take to mean that he must have been the only one on the Harvard Law Review who never learned how to look something up, or never expressed any curiosity about something that would bear on the facts at hand. But we have to remember that he was the only national Democrat, the Democrat of national standing, to oppose that bill of ours, that named in that awful legislative language, the Born Alive Infants Protection Act, the most modest first step of all in abortion to protect simply the child who survived the abortion. One federal judge, Clement Hainsworth, was saying we couldn't do that. A child had survived for 21 days, undergone a surgery, died. When the question was put, was there an obligation to protect that child? The answer was no, that wasn't a child protected by the law. That was a fetus marked for termination. That the right to an abortion was right to an effective abortion or a dead child. And couldn't we simply begin there? No one's quibbling over the human standing of the child. The interests of the woman are quite detached from that of the child. That measure passed the House by a lopsided margin. It was introduced in the Senate by Harry Reid when the Democrats were in control. And it passed without a single dissenting vote, except, of course, for that member of the Senate in the state of Illinois who, through his membership on the chairmanship of one committee, managed to kill that bill. We didn't have penalties in that bill. We thought it as simply a device for planting premises in the law. People say, well, you're going to give us that, and we'll just keep raising questions. Yeah, of course, we won't conceal that. We thought, but look, we'll just try to persuade you each step along the way. And if we don't persuade you, then from that vast volume of 1.3 million abortions, we'll just carve out a handful of lives to be saved, and that we regarded as no trifling point. Jill Stanek, that brave nurse in the Christ Hospital in Oklahoma, Illinois, was the one who blew the whistle on the so-called live birth abortion, where you deliver the child whole and put it in the refuse room to die. And when Jill began going on the radio, nurses were calling in saying, we've been doing that for years in our hospital. We thought this was just a handful of things. It turns out this is just far more frequent than we had suspected. I saw a recent study in England saying that 1 out of 30 abortions ends there with the child surviving. And as Jill remarked, this procedure may become the abortion of choice for the middle class because, actually, Breyer made this argument in the partial birth abortion case, because no instruments are introduced into the body of the mother where they could puncture something, and there are no parts of the child left behind where they could cause infection. Now, that could be our future. Talk about the future of medicine and this issue in the 21st century. But another part may be that the Republicans take a firmer hold in Congress, and perhaps even now, or get the White House again, and it's time to hold hearings on the Born Alive Act to find out how often this is done with a live birth abortion, delivering the child alive and leaving it to die. And the question then is put seriously to the Democrats. You all voted to bar this procedure as a wrong. How much of a wrong was it? What's the kind of penalty that should attach to killing a child born alive? Would be at least as important as a moving violation in traffic? Well, tell us. But this leaves me just a couple of points for me to finish. That simplest measure of all turns out to be one of the most powerful instruments in the arsenal of the pro-life kit, especially when it's connected with a case that achieved iconic standing among liberals, the Bob Jones University case in 1983. You may recall that the university lost its tax exemption because it barred students from dating and marriage across racial lines. The allegation was that the policies of the university were not in accord with public policy. The university could not be sued under the Civil Rights Act because no student had been denied admission to any program of the university on the basis of race. The case was brought by private parties complaining to the IRS. And yet, in all strictness, there was nothing in the statutes or the executive orders of the United States that barred private persons from discriminating on the basis of race in the private choice of a spouse. I remember at the time I wrote, it was mainly in the journals of left liberal opinion, like the New York Review of Books, that you could read ads saying, SWM seeks SWF, single white male, and you know damn well that the New York Review would never do an ad saying, white landlord seeking white tenant, which told us that even on the people on the left, they thought it was still legitimate to discriminate on the basis of race in the private choice of a partner for sex or marriage. But now, in radical contrast to the Bob Jones case, there is a statute of the United States, the Born Alive Infants Protection Act, which provides the ground for private complainants throughout the country to bring complaints to the IRS, and a new administration, 21st century, taking this seriously, could, with its acquiescence, produce a case that is strikingly different. But, my finishing point, the Born Alive Act, even as it stands, becomes the source of disquieting questions that may still unsettle us as we get into this century. As it comes into play finally in asking whether we're indeed clear on the meaning of Roe versus Wade now in its 40th anniversary, during the hearings over Sonia Sotomayor and Elena Kagan, some of us were preparing questions for the Republican staff. And one question was simply to explain what the holding in Roe versus Wade was, because so many people don't grasp it. But another question ran in this way. We would point out that to the nominees, Sotomayor and Kagan, that 2/3 of the Democrats in Congress voted against that bill to bar partial birth abortion. But more critically, the president who appointed you right now opposed the bill to protect the child born alive who survived an abortion. That measure, he thought, was incompatible with the right articulated in Roe versus Wade. And so the question, have we gone past that argument? I'm done, Burt. I don't need it. Have we gone past that argument as something quite untenable Are we clear that Mr. Obama's position, the man who appointed you, has an untenable constitutional position? Or do you think that Mr. Obama's understanding here is still a tenable question in our law, that the right to an abortion entails the right to kill the child who survives the abortion? Well, if that's the case, if the right articulated in Roe does not find its limit even after the birth of the child, or if that is still at this date an open question, well then Roe versus Wade is not all that super-duper precedent that now commands an assent no longer to be questioned. 40 years after Roe, it would appear that that meaning of that case is far from settled.
Hello, my name is Monique Chireau from Duke University. It's a real pleasure for me to be here. As a Duke faculty member, I certainly feel comfortable being here. We appear to be metastasizing to Stanford, but I fear I'm in the minority as an OBGYN physician adrift in a sea of lawyers and legal scholars. However, I will be bold and try to present some perspectives regarding Roe v. Wade. And some scientific issues related to Roe v. Wade that I think deserve some consideration in light of all of the wonderful legal scholarship and discussion, much of which I'm not that familiar with. Now, as has been discussed in some detail here, the Supreme Court's decision has generated controversy on a variety of levels. This decision gave rise to a number of unintended consequences, many of which have shaped the discourse around reproductive rights. In addition, the continuing debate is being informed by advances in embryology, medicine, and epidemiology. And so it's important to consider these consequences in the light of scientific and medical evidence. Again, I'm out of my league here, but someone can correct me if I'm stating things in error. The first arguments, as I understand, in Roe were concerned with procedural and jurisdictional issues, whereas the second round of arguments focused on the medical, social, and constitutional issues. The 7 main themes that emerged are listed here, factual and medical assertions regarding induced abortion and so on. I'm going to focus on that particular theme, as well as the medical context for legal protection of life, and the idea of exceptions for rape, incest, and health of the mother, and what the scientific background might be for those. Now, one of the assertions made during arguments for Roe was that abortion is safer than childbirth. This assertion was not evaluated rigorously based on scientific grounds. A more accurate way to perhaps look at this question would be to ask, is the risk of an abortion at a given gestational age greater than the risk of being pregnant at that gestational age? Or is the risk of abortion at a given gestational age greater than the risk of having a miscarriage before 20 weeks or giving birth after 21 weeks? This is here's some data from CDC's abortion surveillance, which is carried out approximately every 5 years. One of the things that you can see here is that the number of reported abortions, according to CDC, is in the range of 800,000 a year. However, people who study these statistics, like myself, are fairly confident that this is a 30 to 60% underestimate. And especially in view of the fact that California, Delaware, New Hampshire, and Maryland do not report abortion statistics. So anywhere from 65 to 69% are lower than the Guttmacher Institutes. So prior to Roe, it was estimated that approximately 100,000 abortions were performed in the United States. And interestingly enough, the data that are frequently cited saying that there were 1 million abortions and 1,200 to 1,500 deaths per year have not been able to be supported. Of abortions that are performed in the United States, 55% occur in women who have never had an abortion, 37% in women who have had 1 or 2 abortions, and 8% in women who have had greater than 3 abortions. In support of the idea that the estimates provided to the court for abortion deaths were higher than what was actually occurring. In 1960, vital statistics records indicated that 1,579 pregnancy-associated deaths, that's for all pregnancy-associated deaths, including abortion, live birth, and so on and so forth. So at present, the estimate is that approximately 1.3 million abortions are performed annually, making this one of the most commonly performed procedures in the United States. As we know from studies of abortion epidemiology, short-term outcomes include bleeding infection, uterine perforation, and maternal mortality. Long-term complications, there's a clear association between abortion and preterm birth. There is adequate documentation of association with mental health issues, possibly autoimmune disease, and possibly cancer. One of the more interesting facts about abortion mortality in the United States from this paper by Bartlett et al. Shows that legally induced abortion rates have declined over time, possibly with refinements in abortion technology. However, one of the most interesting, and I don't know if this has a laser pointer in it, but one of the most interesting facts is that the risk of mortality from abortion increases dramatically as gestational age increases. In fact, there's a 76-fold increase in mortality between early and late abortion, or stated another way, the risk of death from abortion increases exponentially by 38% for each additional week of gestation. This is clearly not true for pregnancy. So therefore, to say that abortion is safer than pregnancy is just not true. In addition to this, I do want to point out that one of the other unintended consequences of Roe was that it likely contributed to the globalization of abortion. Prior to Roe, abortion was illegal in most nations. I'm not saying Roe led to abortion becoming legal in most nations, but the United States has been and is one of the largest funders of the UNFPA, and Secretary of State Clinton's 2009 speech to the UN clearly defined abortion as a foreign policy priority of the United States. This next slide is very shocking, but I do need to make actually the slide after this, make a point, because we are intimately involved and have been intimately involved with China's one-child policy. This was funded by UNFPA, and we fund UNFPA. It has led to situations like this, the forcible abortion of women at late gestational ages. And I know that people don't want to look at this, but for many people, abortion is an abstract concept. It does not involve the actual seeing of the death of a child, the mutilation of a child, and what it did to this woman to experience this abortion. In China, it's estimated that more than 400 million abortions have been performed over the last 20 years, mostly female. And as a result, the Chinese population is aging faster than that of any other nation in the world. I'll skip through this quickly. Sex-selective abortion has dramatically altered the sex ratio in China, resulting in approximately an estimated 300 million more men over a 10-year period the next decade, in addition to the approximately 100 million more men who currently cannot find. And then in other nations, this is going on as well. Similar statistics are seen in the U.S. diaspora populations, and there's an excellent book on this subject, which has been reviewed by the Wall Street Journal. I won't have time to get into this. Time is flying very quickly. But other issues ensue. The question of eugenic termination. Who is being terminated and why? Racial disparities. African American women undergo abortion at 3 times the rate of majority women. Vulnerable populations. Abortion is used as a cover for statutory rape, molestation, sexual trafficking. And how does all this relate to Roe? It might be argued that complete discussion of the medical factual information about induced abortion did not and could not indeed occur during the arguments. This is one of my favorite slides. This is from in vitro fertilization. This is a very early stage embryo. I love the colors, but I love also what it represents, obviously the beginning of human life. But this sets up some very interesting ideas, and you can call these boundaries or you can call them frontiers. When does pregnancy begin? When does life begin? King Solomon said in Ecclesiastes that no one knows when a life enters into the unborn child. But science is increasingly making strides toward identifying when when fertilization occurs. Now, traditionally, as OBGYNs, we've had practical, medical, and legal reasons for defining when life begins, when pregnancy begins. One of them is that a pregnant woman and her fetus needed certain protections. For example, the nuclear engineer who works in a reactor needs to be protected from radiation. The nurse who mixes chemotherapy in a hospital pharmacy needs to be protected from exposure to chemotherapy. And there are advantages to pushing that definition further back. Why? Women often do not know that they're pregnant and undergo preventable exposures early in pregnancy. Many adult diseases, including hypertension, diabetes, and cancer, have their origins in utero. The problem of when pregnancy begins is a pragmatic one. Upon implantation, the embryo sends out a detectable hormonal signal, human chorionic gonadotropin, which is the basis for current pregnancy testing. This is an arbitrary way to define the onset of pregnancy because it's based on detecting an event, implantation, rather than when the embryo came into existence through fertilization 8 to 10 days earlier. And so for the practical reasons I mentioned above, it's desirable to know when fertilization occurred. recent research is focused on early pregnancy factor and other markers which may identify very early pregnancies. But again, this is pushing back the question, when does life begin? When does pregnancy begin? Similarly, neonatologists are pushing back excuse me, the boundaries of viability, which are approximately now at 23 to 24 weeks gestation. Scientific advances such as surfactant and antenatal steroid therapy have markedly increased survival rates for even the most premature infants. This presents important questions regarding a fetus's likelihood of surviving a late abortion. Furthermore, even at early gestational ages, interventions are being carried out on behalf of the fetus. I'll just choose two: fetal surgery and prenatal treatment of Down syndrome. Fetal surgery is now being performed in the late second and early third trimester and later to correct fetal anomalies, such as duodenal atresia, tumors, and neural tube defects. This is a picture of a fetus where the microforceps are going into the fetus's mouth. This is a surgery to repair duodenal atresia, which is a failure of development where the duodenum is not patent. This is another procedure where a shunt has been placed and is being taped to the baby's hand. And this is a child who had a large, what we call a coccygeal teratoma, a non-malignant growth on the sacrum, which would have resulted in her death, but she underwent fetal surgery, and as you can see, it looks normal. Another boundary frontier is prenatal treatment of Down syndrome. Down syndrome is trisomy 16, where an extra copy of chromosome 16 gives rise to mental retardation, physical anomalies, and shortened lifespan with early onset of chronic disease and dementia. 61 to 93% of Down syndrome fetuses are aborted in the United States. However, the recent research has found that by administration of certain specific proteins, the developmental delays and intellectual problems in mouse models have been shown to be partially or completely reversed, which is very exciting. This is clearly far from going into phase 3 clinical trials, but it's showing that science is beginning to address some of these issues. By treating these mice prenatally, they improve their coordination, they improve their performance on specific tasks. So the concept of abortion being sometimes necessary, excuse me, to preserve the life of the mother is deeply entrenched post-Roe. This idea sets up an apparently irreconcilable maternal-fetal conflict, pitting the mother against her unborn child and setting the stage for abortion for maternal indications. In fact, the evidence suggests that such a conflict in pregnancy does not exist. I'm going to briefly talk about my colleague, Frédéric Armand. He's a Belgian researcher. He's really one of my heroes because he had the guts to begin to treat pregnant women with cancer instead of just terminating their pregnancy. Situations don't occur where the mother's deteriorating condition requires termination of pregnancy. However, increasingly the rationale for induced abortion for maternal indications has been challenged with advances in science. The primary goal is to provide necessary medical care even if such care results in the death of the fetus. An example, women with severe cardiac disease who need to put on cardiac bypass via the cardiac bypass pump. This is necessary when they're decompensating, the point that they are not going to survive and other interventions have failed. There's a 30% fetal mortality, but no one will deny this care to the woman, recognizing that 70% of the time the fetus is going to survive, and B, it's an acceptable risk-benefit balance. In this case, the principle of dual intent or dual effect provides the ethical framework for addressing such situations. Direct use of induced abortion as a primary treatment for medical illnesses violates the Hippocratic principle of primum nocere nocere, first to no harm. Another interesting question is, why do women have abortions? These are papers from the Alan Guttmacher Institute. And what's most fascinating to me about these is there's a long list of reasons why women have abortions. But physical problems with my health, possible problems affecting the health of the fetus, and was a victim of rape or incest are all at the total bottom. And so most of the reasons why women undergo abortion are social reasons. This is another study looking at the question of why women have abortions. And again, these are social reasons. Am I saying that that is not a reason to have an abortion? No. I am saying that that is an excellent opportunity to intervene. If a woman is having an abortion for social reasons, that presents an opportunity. One of the most important 21st century reproductive health issues that will likely come before the court is conscience. A paper appeared in the New England Journal of Medicine called Conscientious Objection, gone awry. I don't know if people saw or were aware of this paper. in which they stated that healthcare providers already enjoy broad rights, perhaps too broad, to follow their guiding moral or religious tenets when it comes to sterilization and abortion. An expansion of those rights is unwarranted. Instead, I'm sorry about the misspellings, patients deserve a law that limits objections and puts their interests first. Federal laws may make room for the rights of a conscience, but healthcare projectors and all those whose jobs affect patient care should cast off the cloak of conscience when patients' needs demand it. Now, a definition of professionalism can be summarized. We as physicians have a fragile relationship with our patients. The potential damage to this bond is great, and damage will occur if the ethical basis for medical practice is neglected. One of the reasons that we're keenly aware of this is Nuremberg. The Nuremberg Tribunal in 1947, where Nazi physicians were tried on charges of torture, they defended their actions by saying that they were only following the law. The court found the physicians guilty and stated that physicians could not deviate from ethical obligations even if legislation demanded otherwise, and they could not escape personal ethical accountability. Here are some other issues that will come before the court. When does pregnancy begin? When does life begin? As we mentioned, the status of the fetus. In a pregnancy where medical or surgical interventions can improve the quality of or save the life of the fetus, can parents instead opt for induced abortion? Surrogacy and egg donation, stem cell research, the status of embryos. To what extent should we be concerned about exploitation, commodification, or coercion when women are paid to be pregnant and deliver babies? Is it right for society to permit women to make contracts about the use of their bodies? What does motherhood mean? What is the relationship between genetic motherhood, gestational motherhood, and social motherhood? And I'm going to skip through this very quickly. And I would like to show you a very brief video. This is fetoscopy. This is showing a 9-week embryo with no danger to the embryo. It's where a fiber optic cable is inserted, and as you can see, this fetus is reacting to the light at 9 weeks, bringing up his or her hands. You can see the fingers are already fairly well developed. The face is beginning to develop. This is the umbilical cord. This is showing the placenta. And this is 9 weeks. Again, this infant is moving. You can clearly discern different structures. The umbilical cord is pulsating. And so I would like to just conclude, I know I'm slightly over time, but I would like to just conclude with a sentiment that was expressed at a recent conference by constitutional legal scholar Jerry Bradley. The issue of abortion raises a compelling foundational question regarding law and justice. Who is the law for? For whose benefit do we plan and build and apply this vast apparatus we call the rule of law? This question is foundational because it is prior in status and importance to the question, what shall the law be? It is foundational because answering it right is essential to justice. Anyone can see that even the most refined arrangement of legal rights and duties counts for naught if the strong can with impunity manipulate the foundational question, deny the benefits of law to those they wish to exploit. I will add whether those are women or fetuses. Legal thinkers as far back as the 6th century saw that law is for persons, not the other way around. Persons are the point of law. Law is their servant. Persons are not for the state or the fatherland or the glory of the common law. These beneficiaries, these women and these children and fetuses and embryos, are not entities identified through policy analysis, not the sum of interest balance, the deliverables of a vast progressive agenda. Being prior to law and indispensable to justice, the foundational question must be answered according to the truth of the matter. Thank you.
So the last speaker at a conference like this has a heavy responsibility to be brief. It goes against all my instincts, but I'll try to do that. I was very happy to hear Burt say that he wanted us to think about Roe at 80. Any prediction that I make that can't be disproven for 40 years gives me, I think, a free pass because I'm not likely to be around to see whether I'm proven wrong or not. And I intend to take advantage of that free pass by talking about some new technologies that may or may not happen, some of which I think will almost certainly happen, some of which are already happening, and how they are likely to affect our abortion debates. They may or may not have any effect on the ultimate moral, ethical, and constitutional question, but they will certainly, I think, affect the interests, the settings, the situations in which the questions arise, and those have consequences for our society, for our ethics, and for our law that I think it's worth giving some thought to. I want to talk about 4 technologies, 2 in some depth and 2 briefly. The first technology is called non-invasive prenatal genetic testing. It is a technology that has been commercially available in the United States for about 15 months now and is in the process of unfolding at a soon-to-be explosive rate. The second technology I want to talk about is called pre-implantation genetic diagnosis. It has been available for over 20 years, but it also is in the process of unfolding in the near term in a fairly fast rate because of our increased genetics knowledge, and in the somewhat longer term, and I think a truly explosive rate because of some, I think, likely consequences of stem cell research. The third technology is genetic therapy, gene therapy. I think that may have some interesting implications, though farther off and less certainly. And the fourth technology that I'll touch on only very briefly, much longer term, much less certain, but the possibilities of actually functional artificial wombs. Non-invasive prenatal testing. Until recently, in order to get genetic tests of a fetus, you had to get material from the fetus. You have all left millions of pieces of DNA in this room just in the last 10 minutes, let alone in the last 8 hours. All those are easily accessible and testable. Fetuses do not leave fingerprints, at least outside the amniotic sac. It is difficult to get fetal samples in order to do the testing. In order to do that in the past, you've had to have an invasive procedure. One of them is called amniocentesis, the most common. Happens between 16th and 18th week of pregnancy. Involves a long needle through the abdomen to pull off some amniotic fluid in which there are fetal cells floating. More recently, chorionic villus sampling has been developed. This can be done as early as the 10th week, although it's usually more like the 12th to 14th week. This is an invasive procedure that snips off a little bit of the placenta and brings that out for testing. Both of these procedures are invasive. Both of them are expensive. Both of them are unpleasant. My wife had amnio with her first pregnancy. She didn't like it. She had CVS with her second pregnancy. She didn't like it. I had a vasectomy after her second pregnancy, so we didn't have a third pregnancy. They are also both risky. The risks to the pregnant woman are relatively small. The risks to the fetus are relatively small, but it depends on how large you count those risks. It's about 0.5% of a miscarriage rate at a time when the normal miscarriage rate, the usual miscarriage rate for a pregnancy at those lengths is about 1% to 1.5%. So you're adding about 0.5% to the risk. That varies some from procedure to procedure and the expertise of the people who are doing the procedure. This has all changed recently. We can't get pieces of fetus to test without invasion, but it turns out we can get some fetal DNA because some fetal cells will cross the placental barrier, end up in the pregnant woman's blood serum. Those cells die, just as our cells are constantly dying. All of us right now have cells. Millions of cells have died since I started speaking. I don't think because I started speaking, although I'll leave that to you to conclude. Those cells break apart. They dump their contents, including the DNA, into the blood serum. Enzymes break up that DNA into small pieces about 100 base pairs long. Now, your DNA in every cell is about 6.8 billion base pairs long. These are only 100 base pairs, tiny little pieces. But thanks to advances in genetic sequencing technology, one can now take 8 milliliters of blood, approximately 1/4 of an ounce, take the serum out of it, and sequence every piece of cell-free DNA, every of these little 100 base pair bits of DNA in that serum. You can then, from the 5th week of pregnancy on, it turns out that 5 to 10% of that DNA does not come from the pregnant woman, but comes from the fetus, and you can look for things. You can, for example, look for pieces of Y chromosome. The Y chromosome is why my voice is low. Half of you have a Y chromosome, half of you have 2X chromosomes. If a pregnant woman has pieces of a Y chromosome in her bloodstream, in any non-trivial amount, that tells you that she has a male fetus, because she doesn't have a Y chromosome, and a female fetus doesn't have a Y chromosome, only a male fetus. You can use it to test for various trisomies, these conditions where people have 3 copies of a chromosome instead of only 2, the normal 2. This is one of those many cases in life where too much of a good thing is a bad thing. Trisomy 21, 3 copies of chromosome 21, lead to Down syndrome. Trisomies 13 and 18 lead to even more serious conditions. By counting the number of pieces from chromosomes 13, 18, or 21, you can conclude whether the fetus has one of these conditions. It is this, looking at these so-called trisomies or these aneuploidies, for which 4 companies currently offer this testing in the United States. None of them offered it before October of 2011. The leading company, a company from San Diego called Sequenom, expects to do over 120,000 of these tests in 2013. 3 other companies also expect to do it. Estimated market is probably 250,000. That's out of roughly 4 million births a year in the United States, 5 million pregnancies a year in the United States. So it's less than its 2nd full year. It's becoming a substantial chunk of the market. Why is this important? Because now, as early as 10 weeks, which is when this is clinically advised, and perhaps as early as 5 weeks, you can learn information about the fetus. You can learn information about whether it has a trisomy or not. You can learn whether it's a boy or a girl. You can learn its Rh factor status. You can learn whether the person you think is the father is actually the father. All these have been made commercially available. Soon, you will be able to test for single gene diseases. This has been done on a research basis. In fact, the whole genome, all 6.8 billion base pairs of the fetus, have been recovered on a research basis from 8 milliliters of blood taken at the 10th week of pregnancy. Why is this important for us? Because it moves earlier and raises the number of women who will have genetic information about their fetus. There are probably only 80,000 or so amniocentesis or chorionic villus sampling tests done every year in the United States today. Already next year, there will be twice as many of these non-invasive prenatal tests. People will have information about the fetal genes earlier. They will be interested in making determinations about them, and that will cause some pressures. We've already seen some states ban abortion on the basis of sex or abortion on the basis of race. This technology will make abortions for those reasons or abortions for medical determinations or, and you know, I don't think very many parents would do this, but it's a big country and there are a lot of crazy people out there, abortions for hair color or eye color or any other trait that a parent thinks is important. That'll cause legislative pressures, which ultimately will cause some judicial decision-making. Second technology, pre-implantation genetic diagnosis. This one involves genetic testing of the embryo at day 3 post-conception. The embryo at that point is 8 cells. It's kind of like 8 grapes in a water balloon that's filled with clear jello. So there's not a real structure there, and the cells aren't really attached to each other. You go in, drill a little hole in the envelope in the water balloon, which is called the zona pellucida, suck out one of the 8 cells, and do a genetic test on that cell. This was first done successfully in humans in 1990. In the last year for which we have data from CDC, 2009, approximately 8,000 IVF cycles went through PGD. Probably about 3,000 children were born that year after PGD. That's about 0.1% of all the children born in the United States. What can you test for? Anything you want. Can test for sex, can test for disease, Alzheimer's disease, Tay-Sachs disease, Huntington's disease. You can test for whether the embryo would be an HLA match to provide bone marrow or cord blood to help save the life of an older sibling, the so-called save your sibling cases. There aren't very many of them, but there are some. This is going to expand dramatically soon because instead of just testing for 1 or 2 things with that single cell, we will be able to test for the entire genome. Whole genome sequencing is getting cheaper, faster, more reliable. 10 years ago, it cost $500 million to sequence a whole genome. Today, you can get yours done for $7,000 down the road here, $3,500 if you go in for a group discount. The $1,000 genome is probably less than a year away. If you can test that 3-day-old embryo for all genetic conditions at once, it becomes a more attractive proposition. The problem with PGD is you have to use in vitro fertilization. Because if you conceive the old-fashioned way, at day 3 post-fertilization, that 3-day-old embryo is somewhere halfway down one of the woman's 2 fallopian tubes, and good luck finding it. If you conceive through IVF, you know exactly where that embryo is. It's in a petri dish. IVF is a pain, at least for the woman. This is one of those many ways in which life is unfair. Egg harvest is unpleasant, it is painful, it is risky. About 1% of women who undergo egg harvest every year end up hospitalized as a result. Every few years, someone dies from it. It's not incredibly risky. 150,000 American women voluntarily undergo it each year. But it's not fun, and it is expensive. Sperm harvest, on the other hand, is usually not difficult, not unpleasant, and I don't think any male has ever been hospitalized as a result of sperm donation. So life is unfair. IVF is going to be a rate-limiting factor with respect to PGD in the near term. But move with me 20 or 40 years out, halfway to Burt's challenge of Roe at 80, 20 years out. Another technology that's been mentioned today, induced pluripotent stem cells, may lead to a vast expansion of IVF. These are cells that are similar to embryonic stem cells. They are not currently identical to them. Most researchers I know who support continued human embryonic stem cell research do it because they know that the iPSCs are not the same as HESCs, and they want to understand better what the differences are and the similarities are and how to make the iPSCs more like the embryonic stem cells. But the idea behind this is to make replacement cells. Burt has a heart attack. Sorry, Burt. You survive. Good news. But your heart's damaged and you can no longer run a marathon. We want to make new heart muscle cells for you, put them in, have them fix your heart. If you were a mouse, we could do this already. But if we were mice, we could cure all diseases. The problem right now is if we make those from a human embryonic, the problem is we don't know, there are a number of problems, but one problem is if we put cells from a human embryonic stem cell line into Burt, his immune system would attack them. If we took his own skin cells, turned them into induced pluripotent stem cells, turned those into cardiomyocytes, the heart muscle cells, put those into Burt, his immune system would think they were his. It's a very, very exciting area for reasons having nothing to do with reproduction, but there's a reproductive angle to it too. What if we took skin cells from Radhika, turned them into induced pluripotent stem cells, and then turned them into eggs? No egg harvest. instead of 30 days of hormone treatments and shots, instead of a 1% chance of hospitalization, instead of $15,000 of expense, she has a little bit of a skin biopsy that turns into eggs. How many eggs? Potentially an unlimited number of eggs. Don't try this at home today. I put this 20 to 40 years out there for good reason. I think it will be a long time before this is safe and effective, but I think it will be. What happens then? People who plan to get pregnant can make 100 embryos, can subject each one of them to pre-implantation genetic diagnosis, and can say, I want number 12. That's going to be Andrew Luck. Or they can say, I want this one, she's going to be Carrie Walsh, Olympic sand volleyball gold medalist, also from Stanford, or anything else they want. Now, how accurate that will be is subject to question. There, Andrew Luck may turn out to want to be a poet instead of an architect, but parents will be able to do that. Will we regulate that? How will we regulate that? There's another twist to it, by the way. Maybe I can take Radhika's skin cell, turn it into an iPSC, and make it into an egg. Maybe I can make it into a sperm. Maybe I can make eggs from my stem cells. This opens up another area for some adults who want to have, quote, children of their own, close quote, a phrase I hate because adoptive parents' children are their children in every way except genetic, but genetic children, genetically related children, and gives them a chance to do what they couldn't otherwise do. This can lead to all sorts of Gattaca or Brave New World scenarios. I think actually politically it is likely to happen in part because the IVF clinics are rich and powerful and very successful with their public relations, and in part because this will start not as an effort to get to Brave New World, but because some of the millions of Americans who want to have children who can't today because they don't make eggs or sperm will see this as an answer to their deepest prayer. And then it will move from that to people who have to go through IVF, say because of blocked fallopian tubes, but don't want to go through the egg harvest for understandable reasons. And then it'll move to PGD. So I think this is 20 to 40 years off, but I think this will pose more challenges to how we want to regulate reproduction, challenges that will inevitably bring in Roe v. Wade. The last two technologies I want to talk about only briefly. One is gene therapy or genetic engineering. What if we can just start, instead of picking and choosing and selecting and discarding embryos based on their genes, what if we could take an embryo and change its genes? You started out with a girl, you want a boy? Fine. We'll swap out an X chromosome for a Y chromosome. You've started out with a child who will have a certain disability, you don't want that disability? Fine, we'll swap this out. I think this may or may not ever be possible safely. It's probably not likely for another 30 to 50 years. If it is, that raises some interesting questions. If you're only concerned about the continuing life of that embryo and its ability to progress to be a baby, then this might be fine. If you're concerned about that particular embryo and its genetic definition, then allowing the parents to change a girl embryo to a boy embryo might not be so fine. If you're concerned about discrimination against women, as evidenced by sex disproportionate births, then this might not be fine. New technologies, new issues. Last new technology, artificial wombs. This is an odd one, and I don't know, Dr. Chireau, maybe you've seen this. About every 10 years or so, I see a news article that a scientist, and it's always in Japan, has brought a goat to term, and it's always a goat or a sheep in an artificial womb. I never see a scientific publication about it. This is really hard, and I think in terms of the mechanics, at least in early pregnancy, maybe in the last, maybe after the 20th week, I could imagine sort of a super incubator. Early pregnancy, a mechanical womb, I think, is perhaps never going to happen and is a long way away. But let's go back to stem cell treatments. What if in 20, 30, 40 years, we could grow a womb, grow a uterus, attach it to a machine that provides it with appropriately oxygenated and glucose-filled blood, and grow it from there? What does that do to the abortion question if viability, given a move to an artificial womb, extends from the very moment of fertilization? I think that's another area where new technologies may raise new issues. That's probably the farthest out of these technologies. I wouldn't put any money on it, not even a buck today, but I wouldn't put a lot of money against it if I've got a 40-year time frame. So, in conclusion, technology will affect the context for abortion fights. It may or may not affect your view of the deep moral issues, but it will affect the situations in which they arise. It will affect the interests of different parties in them. It will affect the politics of abortion. And the only thing I can confidently predict of all the technologies I told you about is I'm going to be wrong about some of them. And there'll be other technologies I haven't mentioned and haven't thought about that will happen. The technological progress in biosciences is fast and accelerating, and I wish I were going to be around in 40 years to see what happens. Thanks.
My sense is, as Hank was speaking, all I could think of was the Prometheus stealing fire from the gods. Human knowledge is our greatest benefit. Human knowledge is our greatest threat. Sometimes the more you know, the less good it is. Is there any questioning from the audience? We have just a few more minutes until the session is over. And rather than do cross-questioning, I think we'll see if anybody has a statement from the audience. Good.
Yeah, so I just wanted to comment that I thought it was very prudent that the organizers picked today for this meeting, since it is International Women's Day. But I have to say I was a little bit disappointed, especially in this panel, that women's changing roles in society and the changes in sort of reproductive rights that go along with that wasn't mentioned. So I was curious if you guys could comment on how changing gender norms and the changing role of women in families may in fact impact the discussion around abortion rights as well.
Yeah, I mean, to be fair, we weren't tasked with...
Well, did you want to answer that?
Just briefly, I mean, to be fair, we weren't really tasked with that as our panel's mission. I do think that the issue of changing gender roles is very important, mostly because I think that from my perspective as a gynecologist seeing women struggle with these and having to struggle with these roles as myself, there's a lot of confusion. I think that on the one hand we had a Victorian model which stated that women stay home and men go outside the home and work, and then we had feminism saying, no, that's wrong. And now we have a generation of women, it's very interesting to me to see, who feel that they've been shortchanged. They said, this model didn't work, that model didn't work, what do we do now? I think the role of reproductive technologies now comes back into the hands of women, many of whom tell me when they come to see me, I don't want chemicals in my body, I don't want an IUD. I need to have, say, a method of fertility control that takes into account my need for it to be reversible, easy, and non-toxic. And that, in a sense, is really where I see things as being right now. To some extent, a lot of women in this generation are rejecting the idea that you can have it all, and I can speak from experience that you can't have it all, that's an illusion. It's like a desert mirage that you struggle toward as you're dying of thirst, you get there and you find it doesn't really exist. But I feel that reproductive technologies will not solve that issue. They just will not, and that's just where I am.
At the same time, to chime in, I think that technology could definitely transform our understandings of women's role and their role, particularly in reproducing in society. So Hank's suggestion of the potential for an artificial womb, right? Now, what would that do to the idea that abortion and gestation are inevitably connected to women? If you can have external wombs, how does that that transform women's role? Similarly, the potential for creating eggs from induced pluripotent stem cells, or creating sperm, fertilizing these sperm and egg, cloning, all of these could kind of transform women's roles, and some might suggest achieve a sort of biological equality for women that puts them on an equal footing with men. Now, I tend to be skeptical of that, and so far the technologies that we currently possess, I think Dr. Chireau is correct, suggest that they come at a great price for women. So the idea that women can postpone childbearing and still continue to have children later and later in pregnancy, later and later in life with the assistance of technology, for many women has become a mirage, or that they've been barraged, and we see these Susan Sherwin, No Longer Patient, and all of these books being written about that. But perhaps the promise of new technology could be transformative.
And on the flip side of that, the change, not only will technology change reproductive issues and change culture, but culture will change how the technologies get used. Changing cultural views of women's roles will inevitably have consequences for this kind of debate, whether at the moral level or just at the practical and legal level. Predicting how those roles are going to change in the future, I think, well, it's always easy to make predictions. It's just hard to be right.
Well, I assume that even if relations were dramatically altered so that men were bearing the children, we would still be left with the question of that infant in the womb, that newborn. What dignity attaches to that newborn? Are we still free to kill that newborn for just any reason? I think Hank really confirms my point. If we elaborate the devices by which we could find out all this information, as you suggest, people may, for different reasons, decide that they want the baby with the dark hair. And at certain points, the baby who will not be good at squash. At certain point, you're going to have to face the question, are you prepared to say that people are ending human lives for reasons that could be called wrongful, unjustified? And are we prepared, as with the case of sex selection, to say, to stop it, it's wrong, we will forbid it? Or we could just retreat and say, no, we just don't want to judge. We're going to leave people free to make the decision according to, which is another radical move, to say for the first time, we will settle with the notion that people may destroy a human life without the need to render a justification. I have this vision, if we have a womb that somehow is off by itself, I could imagine the husband and wife deciding to leave town and leave the womb. And some lawyer's going to come forth acting as guardian ad litem to represent the womb in litigation.
We've known of fathers who weren't there for their children's birth. We've not before known of mothers who weren't there for their children's birth, at least.
I want to suggest an answer to your question, a mathematical equation. And the mathematical equation is, the less difficult it is to bear and rear a child in this society, the fewer abortions there will be. And that any way to change those transaction costs by changing the disproportionate burden on women will alter the abortion formula. Last question, and then we're set.
Great, thanks. This is a rather broad question, and it has to do with what we've learned from Roe versus Wade, perhaps globally. I ask this perhaps in the context of technologies ahead globally, but also actual legal precedent in terms of perhaps definition. I'm asking all this also in the context of developing World University and School. We would like to have, it's a startup university, Creative Commons licensed on MIT OpenCourseware. We would like to have law schools on the web under one umbrella in all 200-ish countries. How does Roe v. Wade as legal precedent, just anecdotally in the very few minutes we have left, have an effect on other countries' jurisprudence and returning to the states?
Well, I don't actually know the impact of Roe on other countries. I know Dr. Chireau was suggesting that there had been an impact. I think studying comparative constitutional law, it's interesting the extent to which you could see sort of convergence across the world. So from Roe, we moved to Planned Parenthood against Casey and a framework of imposing information requirements and waiting periods. And many would suggest that Europe similarly kind of has a model where abortion is freely permitted to women in the first trimester of pregnancy, but together with waiting periods and information and counseling requirements. So many comparative law scholars suggest that there's sort of been a convergence and that the United States, from Roe to Planned Parenthood against Casey, has moved closer to the European model. But in terms of the language and the rhetoric of rights, citing again Marianne Glendon, who Professor Brinig mentioned, the rhetoric is incredibly different. So in the United States, the fetus is not a constitutional person, and a woman has a fundamental constitutional right to terminate her pregnancy. At the same time, that right does not include a right to government funding, and access restrictions exist, and women, as a matter of practical reality, often do not have the right to access an abortion if they can't afford it, if there's no doctor available, and so forth. On the other hand, in Europe, there is no fundamental constitutional right to terminate one's pregnancy, nor is the fetus deemed to be not a person. The idea is a fetus protected. At the same time, the government will pay for a woman to have abortion, and abortion is freely and widely available and accessible. So in terms of the language and the rhetoric of rights, there's a stark contrast between the language and the reality. And the Canadian approach is even different. So if you look at different parts of the world, you see kind of dramatically different frameworks and language, but the results may not reflect that rhetoric.
And if for the comparatists among you, in a remarkable week in February of 1975, the Supreme Courts of Germany, France, Italy, and the United States all passed on the abortion question in 1 week. And you can learn more about the legal systems of each of those countries by comparing those 4 opinions and what happened after them than you can from much else. So that was a great question about the comparative. So I think we've come to the end of an extraordinary 2 days. And thank you, Michael, for helping us set it up.
Well, I've been slotted to make some closing remarks, which is the most dangerous thing to do because there's no way to prepare for this. But I do want mostly to thank our speakers for the day and our attenders, and to just to make a few comments about the conference. One reason we decided to do this conference on Roe at 40 is that, Roe versus Wade has been, so central to so many discussions and controversies in this country, and yet, at least I have the sense, and I suspect many of you will share this sense, that we don't actually talk about it very much. That is, we may talk about it with people that we agree with, but that we actually, there has been a severe shortage of conversation across disciplines and across perspectives. And so our ambition in setting this up for this, on this occasion was to produce a genuinely balanced conference at which we would have people who are experts in the field, but not just the field, but we've had lawyers, we've had philosophers, we've had political scientists, we've had physicians and biologists, we've had historians, and I hope that that has broadened the discussion. And I think we've had people from every range of opinion on the subject. And to my mind, that's what a scholarly enterprise is like. This has not been a pep rally for any one position or another, but a way to come together. And we chose the name for the conference, Roe at 40, what we have learned, because of our conviction that this is actually something we can learn. It's not just something where we have opinions or sort of deep-seated feelings, and we didn't come here just to preach at one another, but to learn from one another, and that can come from this kind of a conversation. And this, I'm delighted with what has taken place, and I hope that you have been too. I said almost, virtually every perspective on the subject has been presented, but to my surprise, almost, it seems to me the one that has not been much presented is my own. And this is surely my greatest fault in organizing a conference, to have left out what I think is particularly important. I should have stuck myself on that jurisprudence panel yesterday, and I'm going to talk primarily about that because David Strauss and Michael Paulson found common ground at the jurisprudence panel in telling us that the legal conversation missed the boat by focusing upon the source of the right rather than focusing on the real issue, which is the rights or moral status of the unborn child. And both David and Michael agreed that that is really what the debate is about. I agree that that is what the abortion debate is about. That's what people care about. But we are a law school. There is such a thing as constitutional law. And I think it does matter to talk about what the underlying legal doctrine is. And I think it matters not just for us as lawyers, but it actually, I think there's a reason why constitutional doctrine is constructed the way it is in a constitutional republic, and that we may miss a little bit in dealing with it. And so the question that I think Roe poses, I mean, one of the many questions, but perhaps a neglected question that Roe poses, is how do we deal in a pluralistic, democratic society with deep-seated disagreements? Now, each of us may wish that the solution to that is simply that the other side let us do what we want. So pro-lifers would be very happy to have to resolve that question in one way, and pro-choice people in another way, but that can't really be the answer because it's really just asking us to assume away the problem, which is the deep-seated disagreement. So how do we do this? And I think we do this through the actual forms brought to us by the Constitution. And this is where I think maybe David and Michael led us astray, because in my view, this is not a subject which our Constitution gives to the courts to decide. Now, that's a complicated, a long argument. We heard a good bit of that from Judge Randolph channeling the great Judge Friendly, and I'm not going to go into enormous detail about that, except to say this, that the idea of substantive due process is a very questionable notion. The idea of privileges and immunities of citizens of the United States under the 14th Amendment is, I think, historically a somewhat less questionable proposition, but not very well grounded in current practice. But the most solid core of these ideas is that the deep-seated consensus, deep-seated, commonly held views of the American people have a certain purchase in constitutional law and can sometimes be enforced by the courts, even in the face of legislation to the contrary. I think it's best, this is most easily understood through the Privileges and Immunities Clause, but we do see it also in such places as the second Justice Harlan's concurring opinion in Griswold against Connecticut. There was a fair amount of discussion here of Justice Douglas's majority, but it's actually Justice Harlan's concurrence which has come down to us, I think, is received as the most impressive, the most persuasive of the opinions in the court in Griswold. And in that opinion, Justice Harlan does not take on the role of philosopher and try to decide what the morality or the right and wrong is of the question of use of contraceptives by married couples. Instead, he asks, what's the American practice? And he does a survey of the subject, and he discovers that 49 out of the 50 states allow married couples to use contraceptives. Connecticut is an outlier, right? And there have been a number of other cases in which courts have used a similar methodology where, and I think in 14th Amendment terms, what this is about is the nationalization of rights. That out of the Civil War came the idea that, that individual liberties are the business of the United States. As a nation, we're not going to have a widely different set of individual rights in Alabama than we're going to have in Montana. But that requires a degree of consensus first, right? And the place where I think Roe versus Wade falls short in terms of constitutional theory is precisely that. That at the time Roe versus Wade came before the court, there was certainly not a deep-seated consensus reflected in state law and through Republican institutions in favor of an abortion right. There had been a certain movement in the direction of reform, if reform is the correct word. The historians here tell us that maybe that had been reversed and was even moving in the opposite direction. I don't know. But I do know that it was not yet a consensus. I know also that that these laws were not merely antiquated relics of an earlier era, the way sometimes these things are. That many of them have been recently enacted in accordance with the recommendations of the ALI and the Model Penal Code. These were modern, democratically supported laws that reflected the values of the American people. Now, all that the United States Supreme Court tells us in Roe versus Wade is that there's a disagreement about the underlying moral merits of that position. And indeed there was. But I think that it is just fundamentally an incorrect proposition of constitutional law that the existence of disagreement is a proper basis for overturning the law that's been enacted by legislatures. Sometimes consensus, deep-seated, long-standing consensus, is a proper basis for overturning an outlier state in order to bring a kind of national unity of the conception of rights. But disagreement is not a reason for the court to intervene in the democratic process. And I think that there's some advantages to this, that this is not just pedantry based upon constitutional doctrine. I think that this is the way for a country like ours with different disagreements of opinion to be able to get along. This enables different places within the country. I believe it was Jerry Rosenberg who pointed out how differences of opinion about abortion are quite regionally sensitive. Some states feel one way, some states feel another. This enables each of those communities to be able to pursue the law as best suits them. It also enables, I think, a kind of compromise, that there's something about the judicial method. The judges and the law are relentlessly logical. So if you buy Proposition A, it becomes necessary to buy its logical conclusions. We call this precedent. We follow that this is the very idea of the law. But that means that sort of messy but possibly wise middle ground positions that could be adopted in the democratic process are overlooked in favor of clearer, crisper, more logical, but more extreme solutions. If it is so that there are moral quandaries here, that there's moral queasiness, as I believe Jerry again described, that if people are if there's moral ambivalence, right, perhaps that is better to be reflected in the kinds of laws that would be passed not by judges who are going to take the first precedent and move with it, but rather by legislatures who are going to be trying to please as many people as possible and not step on any more toes than may be possible. And if you don't buy this argument for a question upon, many of us have such strong views on this that we say, well, you know, it's really important, but think maybe about some other questions. Guns, for example. You know, possibly the Second Amendment's language makes it different, because if you really believe the right to keep and bear arms is one that's an individual right specified by the words of the Second Amendment, it may make it a different question. But structurally, it's another question upon which people of goodwill disagree. Why there needs to be a single national answer to questions like this, I don't know. And I think that the actual logic of constitutional theory suggests the possibility of a pluralism here, and that to have single, somewhat dogmatic answers to be imposed by the judiciary and these things is not a good thing. Now. Michael and David, again, are right. That's not what anybody cares about, right? This is not an answer to the abortion question. This is just an answer to how maybe we get along in a democratic republic when we do disagree. But on that note, I'd just like to thank everyone again.